Hi everybody, I thought I'd do this a little bit differently. So this is the motion of the judge decision. So this is the order from the judge for the 7M case, and this is Michelle A. Davis. The above matter came for a hearing on defendant's motion to dismiss on May 27, 2022 before the Honourable Michelle A. Davis, Judge of District Court. Plaintiffs appeared by and through attorney Amber J. Stavig, and defendant appeared and was represented by attorney Christian C. Hendrick. Due to the COVID-19 pandemic, the matter was heard remotely via Zoom. All parties could hear throughout the proceeding based on the reports, files, records, hearing, arguments of counsel, and being fully advised, the court makes the following orders. 1. The defendant's motion to dismiss counts 1 to 10 are denied. The attached memorandum is incorporated herein and made part of this order, and a copy of this order shall be served by parties by e-service and US mail and shall constitute due and proper service upon parties in lieu of personal service. Now, what's interesting there is that there's nothing about costs. So I know that quite often when there are motions in Australia, the party that loses usually has to pay the costs of the other party. So there's been nothing there about costs, so that's the first thing I'll say. So now we've got her decision here, so it's 6 pages. So let's have a look. Background. On March 31, 2022, plaintiff 7M Films and Robert Shin, which are a talent management company and CEO and sole owner respectively, based in the state of California, commenced this lawsuit against Catherine Paulson and Without a Crystal Ball LLC, a Minnesota resident and Minnesota corporation respectively. Ms. Paulson runs several social media accounts with substantial reach, numbering in the tens or hundreds of thousands of followers and attendant engagement, particularly on YouTube and Instagram. The complaint was amended just days later on April 5, 2022, adding Miranda and James Derrick, husband and wife and associates of Mr. Shin, as plaintiffs. The amended complaint pleads 9 courses of action. The 9th count is mislabelled as count 10. The amended complaint skips from count 8 to count 10 against Ms. Paulson, but her LLC, but counts 1 and 2, defamation and defamation per se, respectively, ultimately underlie the remaining counts. Plaintiffs allege that Ms. Paulson, via her Instagram page and other social media, defamed the plaintiffs by posting false statements about 7M and associated individuals. Plaintiffs' business in the field of social media communications and marketing, as well as brokering deals between performers and particularly dancers and commercial venues. Defendant, in her social media posts, as listed by plaintiffs, claims that plaintiffs, in addition to their commercial ventures, are involved in Shekinah Church. Actually, she spelt that wrong. Should be a H on the end of Shekinah, but anyway, semantics, hey? Are involved in Shekinah Church, which plaintiffs claim that defendant characterises as a cult. The plaintiffs claim that the defendant has acquired and published court documents from litigation involving plaintiffs which were subject to a protective order, as well as the defendants claim that plaintiff engaged in criminal conduct including human trafficking, waterboarding and kidnapping. Plaintiffs' other claims are rooted in the same alleged defamatory conduct by the defendant, but are pleaded as tortious interference with contracts, intentional interference with prospective advantage, deceptive trade practices, negligence, and internal infliction of emotional distress. Defendants have not yet filed an answer, and that is the point. They have not actually responded to it. They filed a motion to dismiss. So now they have to file an answer. Defendants now bring a motion to dismiss pursuant to Minnesota Civil Procedures 12.02e, arguing that the complaint fails to state a claim upon which relief can be granted. Plaintiffs filed a responsive memorandum and defendants likewise filed a reply memorandum. A motion to dismiss inquires of legal sufficiency of a complaint, Witzman versus Lehman and Flom, 601 NW2D 179185, Min 1999. The only question before the court on Rule 12.02e motion is whether the complaint sets forth legally sufficient claim for relief. Royal Realty Co. and 1169 NW2D 667 670, Minnesota 1955, Martins versus Minnesota Min and Manufacturing Co. 616 NW2D 732740, Minnesota 2000. The court does not consider whether plaintiff can prove the alleged facts. Royalty Realty Co. The account must only consider only the facts alleged in the complaint, accepting those facts as true, must be construed as all reasonable inferences in favour of the non-moving party. But yes, so what they're saying is that for the motion to dismiss, the question before the court is whether the complaint has been set forth properly. Now, they don't consider whether the plaintiff can prove the facts because it's assumed that those facts are true. So it says, the court must only consider the facts alleged in the complaint, accepting those facts as true, and must construe all reasonable inferences in favour of the non-moving party. So at this point, 7M are the non-moving parties, so everything is assumed is true, and it's up for, without a crystal ball, to show that they're not. Under Rule 12.02, if matters outside the pleading are presented to and not excluded by the court, the motion must be treated as one for summary judgment and disposed of as provided in Rule 56, Minnesota Civil Procedure 12.02F. In this matter, neither party submitted affidavits presenting matters outside the proceedings, so Rule 12.02 does not apply. When determining the motion to dismiss, the court takes the facts alleged in the complaint as true. A claim is sufficient against the motion to dismiss for failure to state a claim if it is possible on any evidence which might be produced consistent with the pleader's theory to grant relief demanded. To claim a claim for defamation, the plaintiff must prove that the statement was false. That's the first thing. 2, it was communicated to someone other than the plaintiff, and it tended to harm the plaintiff and lower him or her in the estimation of the community. So, 7M, interesting, the plaintiff must prove, 7M must prove the statement was false, that it was communicated to someone other than the plaintiff, and that it intended to harm their reputation. And that's for each of those statements, that's what you've got to look at. And there's a case there. When plaintiffs are alleged in libel or defamation of public figures, heightened standards apply in order for conduct to be considered defamatory. Public figure is one whose views and actions with respect to public issues and events are often as much concern to the citizen as the attitudes and behaviour of public officials with respect to the same issues and events. Individuals may become public figures through no purposeful action of their own, by assuming souls should be roles of a special prominence in the affairs of society, or by thrusting themselves to the forefront of particular public controversies in order to influence the resolution of issues involved. And you've got a couple of case laws there. A case, so where it's got here, Jadwin versus Minneapolis Star and Tribune, says quoting Goetz versus Robert Welsh. So it means that this statement here, that the first part of it came from Goetz versus Robert Welch, and that this part here was quoted in Jadwin versus Minneapolis Star. So when you always see the word quoting, it means that the court has used a statement from one action. So it could now be, it could have 7M Films and Katie Joy, without a crystal ball, quoting Goetz and Robert Welsh, etc., etc., etc. Now, Minnesota courts have adopted the New York Times standard. In order for a public figure to prevail in defamation action, they must show actual malice, which is that the alleged lie was a knowing one or uttered in reckless disregard to truth. Rose versus Koch. Furthermore, journalistic outlets have qualified privilege against claims of defamation if they publish fair and accurate reports of public records. Larson versus Gannett, Jadwin versus Minneapolis Star and Tribune. Truth is an absolute defence to defamation. I've always said that. She did not plead anything. She could have, in fact, we have substantial truth, we have public opinion, and we have honest and fair reporting are just three off the top of my head that we have. But yes, truth is an absolute defence. She's not filed a defence. The question of whether a statement's language reasonably conveys a defamatory meaning is one for the law courts to decide in Harman versus Heartland Food Co. This gatekeeper function has long been recognised as common law in this state. Whether a defamatory meaning is conveyed depends on how an ordinary person understands the language in light of surrounding circumstances, Gadwin versus Bentland County Co-op. If the words are capable of a defamatory meaning, it is for the jury to decide whether they are in fact so understood. So this is why jury trials are really important, particularly for defamation, because it is about the ordinary reasonable person test. Does a reasonable ordinary person, upon reading that statement, how do they interpret what they said? So, for example, if one of the allegations is about human trafficking, if her statement about human trafficking, would a reasonable ordinary reasonable person read that statement and go, 7M must be involved in human trafficking? That's the test. The case before the court turns on whether allegations in the amended complaint, taken alone and assumed to be true, form a legally consignable claim for relief. While defendants provide an admirable summary of the Minnesota and United States law concerning defamation involving public figures, and argues that the plaintiffs will be unable to prove that defendants acted with actual malice, those issues are not properly before the court in the present procedural posture. Assuming arguendo that all plaintiffs are public figures and are subject to actual malice standard, plaintiff's amended complaint pleads actual malice. See amended complaint. Whether they are able to prove that defendants acted with actual malice is another matter, which is not before the court presently, because defendants' motion to dismiss is pursuant to Minnesota RC Civil Procedure 12.02e, and no information outside the amended complaint has been submitted to court. So they're saying that 7M actually played actual malice, and in their motion to dismiss, they've not actually done anything to put anything to dismiss that. So at the moment, everything that 7M has said is true. Because yes, they quoted laws and public figures, but they didn't actually deal with the fact that there's an allegation of actual malice. Minnesota is a notice pleading state which requires that the plaintiff include information sufficient to fairly notify the opposing party of the claim against it. Generally, a pleading in a defamation case requires that defamatory matter be set out verbatim. Monano versus Cookson Times. Without setting forth the published words which are alleged defamatory, the court has no means of ascertaining their actionable quality. American Bank Co. versus Kingdom Pub Co. When a newspaper article is allegedly defamatory, a plaintiff needs to set out the portions of the article that contains the defamatory matter. In their complaint, plaintiffs set out in great detail statements with dates, web links and either quotes from the defendants or apparently summaries of posts containing the table stretching from page 4 to 12. See amended complaint. In at least two of the entries in that table, dated April 1, 2022 and April 2, 2022, and located on pages 10 and 11 respectively, plaintiffs appear to quote verbatim defendants making public statements on social media, accusing the plaintiffs of engaging in human trafficking. Exercising its gatekeeper function, the court finds at least those statements convey a meaning which is reasonably defamatory. Hartman versus Heartland. Accordingly, because the plaintiffs have pleaded properly alleged facts, if proven at trial, will entitle them to relief. And with the parties apparently in agreement that the claim of defamation is dispositive to the other counts in the amended complaint, defendant's motion to dismiss is denied. So so the judge has already stated that because they properly played out the allegations, that the statements that have been conveyed could be reasonably seen as defamatory. And in her motion to dismiss, Katie Joy did not even do anything to even, she stayed well away from that. So that's why the motion to dismiss was filed. So where we go from here is she now will have to do her defence, which is really going to be interesting because the court has already, so according to this, the court finds defendants appear to quote verbatim, defendants making public statements on social media accusing plaintiffs of engaging in human trafficking, exercising its gatekeeper function. The court finds that at least those statements convey a meaning which is reasonably defamatory. She's been backed into a corner now. She's going to have to admit that they were defamatory, or she's going to have to plead the truth defence and prove that they do engage in human trafficking. So this is going to be really, really interesting. So watch this space. I hope you have a great day. Bye for now.